The Consumer Rights Act 2015. This lecture discusses the Consumer Rights Act 2015 and the areas of the module it influences. We start with some background to the creation of the Act and continue with an overview of its main provisions, highlighting its departures from previous legislation students of contract law will be familiar with. This is followed by a section consisting of a practical summary of the information. The lecture finishes with a short discussion of a relevant problem question. Background. We start with a presentation of some background to the creation of the Act. There had been a wide academic debate on the need to reform consumer protection provisions in English law, specifically on the issue of the treatment of unfair terms. For example, it was widely acknowledged that there was a significant overlap between rules over exclusion and limitation clauses contained in the Unfair Contract Terms Act of 1977 and the Unfair Terms in Consumer Contracts Regulations of 1999. In addition, the Unfair Contract Terms Act is a complex statute, making it difficult to understand, particularly for the non-lawyer reader. Also, parts of the unfair terms in consumer contracts regulations are expressed in language which is alien to English readers, lawyers and non-lawyers alike. There is also the fact that the earlier legislation, in often concentrating on protection for consumers, ignored the fact that small business contractors may well be in just as disadvantageous a position as regards bargaining power as the individual consumer. Concerns about these issues led to the Department of Trade, as it then was, asking the Law Commission and the Scottish Law Commission in 2001 to review the legislation. That review was completed and the results and recommendations, together with a draft bill, were published in the Law Commission's 2005 report on unfair contract terms. The following are the main points to emerge from the 2005 recommendations. Both the Unfair Contract Terms Act and the regulations should be replaced by a new unified Unfair Contract Terms Act. Only the natural persons should be regarded as consumers, and then only when acting for purposes unrelated to any business in which they run. This, by the way, would have the effect of reversing the decision in R&B Customs Brokers versus UDT from 1987. Certain terms which were effective to exclude liability by virtue of the Unfair Contract Terms Act, for example under Section 2.1, should continue to be ineffective. Most terms in consumer contracts, whether or not negotiated, should be subject to a test of reasonableness, with a key exception relating to core terms, for example the price. Even these needed to be transparent and in line with the consumer's reasonable expectations in order to be valid. The test of reasonableness to be applied should be whether the clause was a fair and reasonable one to include in the contract. Factors to be considered in making an assessment should include whether the clause is transparent, its substance and effect, and the circumstances in existence at the time it was made. Lack of transparency could in itself render a clause unfair. Guidelines for reasonableness, such as those contained in Schedule 2 to the Unfair Contract Terms Act, should be included in the new Act. The contra proferente should be given statutory force in consumer contracts. You will remember that the rule means that limitation and exclusion clauses are interpreted against the person trying to rely on them. An indicative list, broadly similar to that included in the regulations, should be part of the new Act. Examples of unfair clauses would be included in the explanatory notes published with the Act. The burden of proof of fairness and reasonableness in consumer contracts would rest on the party seeking to rely on the clause. In business-to-business contracts, exclusion and limitation clauses, but not other terms, which are contained in written standard terms, would continue to be subject to fair and reasonableness test. This is similar to Section 3 of the Unfair Contract Terms Act 1977. The effect of Sections 2.1 and 2.2 of the Unfair Contract Terms Act would also be preserved. The burden of proof would again rest on the party seeking to rely on the clause. The requirement of reasonableness imposed on attempts to exclude liability for the statutory implied terms as to description, quality, and fitness for purpose in relation to business contracts would no longer apply. If such exclusions are contained in written standard terms, however, they would continue to be caught by the replacement of Section 3 of the Unfair Contract Terms Act. A new category of contract, small business contracts, would be created. This would involve a business contractor that has 9 or fewer employees. In small business contracts with a value of less than £500,000, any terms other than, for example, core terms that have been put forward as part of the other party's written standard terms would be subject to the test of fairness and reasonableness. The burden of proof, however, would here rest on the party challenging the term. There were, of course, other, more detailed provisions in the Law Commission's proposals, but the above points highlight the main changes which in 2005 the Law Commission proposed from the existing position. If enacted, these proposals would also have had the effect of leading to greater clarity. In particular, it would have been helpful for there to be one piece of legislation dealing with this area rather than two. In 2006, the government indicated that, subject to a regulatory impact assessment, the Law Commission's recommendations. However, steps were not taken to implement the Law Commission's full proposals, and this was initially to some extent attributable to the negotiations surrounding an EU draft Consumer Rights Directive, which at one stage included detailed provisions on unfair terms. However, in 2012, the Department for Business Innovation and Skills requested the Law Commission, particularly in light of the case of the Office of Fair Trading versus Abbey National in 2009, to update, in relation to consumer contracts, their 2005 report. In July 2012, the Law Commission published an issue paper, and in March 2013 published their advice to the Department for Business Innovation and Skills. In June 2013, the government published a draft Consumer Rights Bill, Part 2 of which dealt with unfair terms. On the 23rd of January 2014, a Consumer Rights Bill was introduced. The two headline revisions to existing legislation introduced into the bill were as follows. One involved consumer remedies for faulty goods, and the other unfair terms in consumer contracts. Consumer remedies for faulty goods. UK consumers have a legal right to reject faulty goods. This means a right to a refund act within a reasonable time. By contrast, under the European Consumer Sales Directive, consumers' first recourse is to repair or replacement. In the bill, it was recommended that the right to reject should be retained in the UK as a short-term remedy of the first instance. It was recommended that in normal circumstances, a consumer should have 30 days to return faulty goods and receive a refund, with limited flexibility for special circumstances such as perishable goods or goods with both parties know they will not be used for some time. Unfair terms in consumer contracts. Price comparison websites put increasing pressure on traders to offer low while making profits from other charges. Since 1994, under an EU directive, the courts had the power to assess fairness of terms in consumer contracts but may not look at the amount of the price. In 2009, the issue of what constitutes the price came to the fore in litigation. This is the Office of Fair Trading versus Abbey National case mentioned earlier. The case involved bank charges for unauthorized overdrafts. The Court of Appeal thought that the bank charges could be assessed for fairness, while the Supreme Court thought that they could not. In the bill, it was recommended that the courts should not interfere with prices which are transparent and prominent, but where charges are tucked into small print, the courts should have the power to assess them for fairness. These recommendations are to be found in Part 2 of the Consumer Rights Bill 2014. We now move on to consider the provisions of the new Act. The Consumer Rights Act in October 2015. Its aim is to consolidate and clarify consumer rights. It does not affect business-to-business contracts, for which the provisions of the Sale of Goods Act 1979, Supply of Goods and Services Act 1982, and the Unfair Contract Terms Act 1977 remain in force. However, where the contract is made between a business or trader and a consumer, the law in relation to implied terms and exclusion clauses will undergo fundamental changes to the existing legislation. This includes the Unfair Terms in Consumer Contracts Regulations of 1999 and the Consumer Protection Distance Selling Regulation. In Part 1, the Act covers goods, in Chapter 2, digital goods, in Chapter 3, and the supply of services, in Chapter 4. For each, it sets out a blacklist of implied terms and the relevant rules on mandated remedies. Also, there is information on how attempts to exempt and limit liability will be assessed. The provisions of the Act will be familiar to those who have studied contract law and the incorporation of implied terms into contracts. There are no radical departures from prior legislation, and it is better to think of the Act as a consolidating statute, clarifying and augmenting existing protections for consumers, rather than building a brand new regime. For contracts to which the Act applies, implied terms derived from earlier legislation will cease to apply to consumer sales. These are sales where the buyer is an individual, not buying in the course of business, and the seller is a trader, meaning a person acting for purposes relating to their trade or profession. For example, Sections 9, 10, and 11 require goods to be of satisfactory quality to be fit for their particular purpose and to match their description, reflecting provisions in the Sale of Goods Act. Sections 13 and 14 cover the sale of goods by samples or models seen before purchase. This, for example, covers the situation where a consumer sees a product on display and then purchases a boxed item without further inspection. More specifically, the sections of the Consumer Rights Act generally repeat the wording of the equivalent Sale of Goods Act section, so that the substantive protection given to buyers in consumer contracts is essentially the same as that under the Sale of Goods Act. The Consumer Rights Act does not refer to implied terms, but states that the contract is to be treated as including the relevant term, which in effect amounts to the same thing. There are, however, two additional sections under the Sale of Goods Act provisions. First, under Section 15 of the Consumer Rights Act, if installation of goods by or on behalf of the trader forms part of the contract for their supply, an incorrect installation will mean that the goods will be treated as not conforming to the contract. Second, under Section 16 of the Act, if the contract for the supply of goods includes digital content, then if the digital content does not conform to the contract, the goods will be treated as not conforming to the contract. Finally, it should be noted that the Consumer Rights Act refers throughout to the supply of goods. This means that it's not only sale, but all other contracts under which goods are supplied, such as hire purchase, hire, or work and materials. For example, in a contract to build a garage, the bricks and other materials will be supplied for the purposes of the Consumer Rights Act. The Sale of Goods Act deals only with sale, and other contracts under which goods are supplied are dealt with by similar implied terms set out in the Supply of Goods and Services Act of 1982. Subsequent sections set out rights to possession and ownership and the remedies available to consumers. Especially important are the rights set out in Section 20. In Section 31, there are terms which cannot be excluded or restricted. This is known as the blacklist. The language is updated somewhat with the old Sale of Goods Act references to condition and warranty gone, but the short-term right to reject remains. However, after 30 days, replacing the more flexible concept of acceptance under the Sale of Goods Act, this is replaced by a right to repair and replacement as the primary remedy. Only if there are no adequate arrangements for repair and on replacement will the right to reject remain. Perhaps the greatest innovation can be found in Chapter 3, which covers digital goods which are now given equal to physical goods. This chapter follows similar issues as in Chapter 2. Remedies here include consequential damage, for instance to software and hardware, although one needs to keep in mind evidential problems in proving such losses. Chapter 4 relates to the supply of services and reflects the provisions of the Supply of Goods and Services Act. An important section will be Section 49, covering the requirements to act with reasonable care and skill, reinforcing the ability to hold service providers to account for negligent liability under the contract. This is linked to Section 57 and the limits to exclude liability. The contracts for services, important pre-contractual statements are now implied into the contract in Section 50. In Part 2, the Act provides a general safety net to prevent unfair terms, reflecting unfair terms in consumer contracts regulations provisions and contained in Schedule 2, which are outside the blacklist in Part 1. Section 63 of Part 2 has a list of terms which may or must be regarded as unfair. This will need to be read in conjunction with Section 64, which has a list of terms which cannot be assessed for fairness. In its treatment of what we call unfair terms, the Act moves closer to the European standards of fairness as opposed to using the Unfair Contract Terms Act language of reasonableness. For example, the reasonableness test from the Unfair Contract Terms Act is replaced by fairness, including for negligence, which makes it much more in line with the regulations. Certain key prohibitions, like the Unfair Contract Terms Act ban on attempts to exclude liability for death or personal injury, remain. General definitions are set out in Section 2 of Part 1. A trader, as we saw earlier, is a person acting for purposes relating to the person's trade, business, craft. A consumer is an individual acting for purposes wholly or mainly outside the individual's trade, business, craft, or profession. A person is not necessarily a consumer. All this means that the business is defined much more in line with the principles of the Unfair Terms and Consumer Contracts regulations. So a business acting outside its normal course of business cannot fall within this, but would need to rely on the existing legislation under the Unfair Contract Terms Act. This is important because it means that corporate entities cannot be regarded as consumers. This was a much criticized aspect of the regulations, which remains largely unchanged. The definition of goods leads to some important distinctions in the law of consumer protection. Goods under the Act are any tangible movable items, which includes utilities if and only if they are in a limited volume or set quantity. This will make important changes to the protection of consumer rights. It will mean that there are two schemes operating now to different types of contracts. There is a vast amount of law in relation to consumer law, and we see an increasing distinction between commercial contracts and consumer contracts. This reflects an increasingly paternalistic approach to vulnerable contracts, with the contract remaining for commercial contracts. This is a long-term trend in European law which has hugely influenced the Consumer Rights Act. It remains to be seen whether it will be reversed, arguably to the detriment of consumers, in the post-Brexit revamp of English law. So far, we have presented some background to the process of law reform that led to the creation of the Consumer Rights Act 2015. We also saw a brief breakdown of the sections of the Act and presented its main aspects. The following section of the lecture offers a practical view of what the new Consumer Rights. This part of the lecture summarizes the information provided earlier, focusing on clarifying what the Act means practically for consumers currently going about their daily activities. The emphasis is on the experience of the customer when dealing with faulty goods or inadequate services. As we saw above, as was the case with the Sale of Goods Act, under the Consumer Rights Act, all products must be of satisfactory quality, fit for purpose, and as described. The rules also include digital content in this definition. So all products, physical or digital, must meet the standards as explained in the discussion that follows. We will now discuss what is the meaning of the various quality criteria. Satisfactory quality means that goods should not be faulty or damaged when received. The consumer should consider whether a reasonable person would consider the goods in question of satisfactory quality. For example, bargain products won't be held to as high standards as luxury goods. Fit for purpose, on the other hand, means that the goods should be fit for the purpose they are supplied for, as well as any specific purpose made known to the retailer before he was agreed to buy the goods. As described means that the goods supplied must match any description given or any models or samples shown at the time of purchase. For example, if you buy a new printer, there is an expectation that it will work for longer than a few months without needing repair. If you buy a professional printer, the expectation might be that it would work for a few years. If you want your printer to handle large volumes of paper and to do double-sided printing, and this was part of the description of the product, then it is a requirement that it does that. This means that if you specifically asked for large volumes of paper, a printer that can handle everyday use of a few pages but not more will not conform to your agreement. Also, the printer needs to do everything the sample in the shop was shown to do, even if a function is considered relatively minor. If the item you bought does not conform to the contract, who should a claim be made against? If a purchase doesn't satisfy any one of the criteria outlined above, the customer will have a claim under the Act. When making a claim under the Act, there are several possible ways of resolving the issue depending on the circumstances and on what the consumer wants to have done to remedy the situation. It is important to remember that rights under the Act are against the retailer, the company that sold you the product, with which the computer has a direct contractual relationship, not the manufacturer. There may be additional rights arising out of warranties offered by the manufacturer or in tort law which are not covered by this legislation. The warranty notice from the manufacturer of your printer, to use the earlier example, will give you therefore additional rights, including perhaps service abroad, but this does not take away your rights under the Act to approach the shop you bought. What one can claim depends on how much time has passed since you made the purchase. Under the Act, the consumer has a legal right to reject the goods that are of unsatisfactory quality, unfit for purpose, or not as described and get a full refund as long as you do this within 30 days from the date of purchase. After 30 days, the legal requirement to a full refund if the item develops a fault is lost, although some sellers may offer an extended refund period. This will be an express term, not implied by the Act, of the contract of sale in that instance. Express terms are found in the terms and conditions of sale of every specific retailer. Incorporation of express terms is covered in the syllabus of your contract law module. Also remember that no-fault returns, if for instance you change your mind about the product, are express terms including in some, but not all, contracts of sale. You may be disappointed therefore if you change your mind about your printer and wanted a different one and the shop refuses a discretionary refund or change, but this will not be a violation of your statutory rights. A right to a refund doesn't apply to purely digital products, however, music, games, or applications bought as downloads. A digital product can, however, be repaired or replaced if it develops a fault. If this isn't possible or is unsuccessful, the consumer will have the right to receive a price reduction. The 30-day time limit is shorter for perishable goods, where the period will be determined by how long it is reasonable to have expected the goods to last. For example, yogurt would be expected to last until its use-by date as long as it's stored correctly. If a claim is brought outside the 30-day right to reject, the consumer has to give the retailer one opportunity to repair or replace the goods or digital content which are of unsatisfactory quality, unfit for purpose, or not as described. One can ask the retailer to repair or replace faulty goods, but they can normally choose whichever would be cheapest or easier for them to do. If the attempt at a repair or replacement is unsuccessful, the consumer can then claim a refund or a price reduction if they wish to keep the product. An entitlement to a full or partial refund instead of a repair or replacement arises in the following circumstance. Or replacement is disproportionate to the value of the goods or digital content. A repair or replacement is impossible. A repair or replacement would cause the consumer significant inconvenience. The repair would take an unreasonably long amount of time. If a repair or replacement is not possible, or the attempt at repair fails, or the first replacement also turns out to be defective, the consumer in those cases has a further right to receive a refund up to 100% of the price they paid, or to reject the goods for a full refund. If the consumer doesn't want a refund and still wants to keep the product or have it repaired or replaced, they have the right to request a retailer to make further attempts at repair or replacement. Why would one prefer a partial refund to a return or replacement? If, for example, you bought a new study desk which arrives flat packed, you would probably spend a lot of time assembling it and you would need it done in order to use it. If you discover that one of the drawers of the desk is misaligned and cannot be assembled properly, you may not feel like disassembling the whole desk in order to send it back. In these circumstances, you would prefer a replacement of the drawer, or perhaps to keep the drawer, if you manage to repair it yourself, and request a partial refund for your trouble. If fault is discovered within the first 6 months from purchase, it is presumed to have been there since the time of purchase, unless the retailer can prove otherwise. During this time, it's up to the retailer to prove that the fault wasn't there at the point of purchase. If an attempt at repair or replacement has failed, the consumer has the right to reject the goods for a full refund or price reduction. If they wish to keep the product, no deductions can be made from a refund in the first 6 months following an unsuccessful attempt or at repair or replacement. The only exception to this rule is motor vehicles, where reasonable reduction may be made for the use of the vehicle after the first 30 days in question. They can request inappropriate price reduction. After the first 6 months, the burden shifts to the consumer to prove that the product was faulty at the time of delivery. In practice, this may require some form of expert report, opinion, or evidence of similar problems across the product range. The statute of limitations on civil claims is 6 years to take a claim to the Small Claims Court for faulty goods in England, Wales, and Northern Ireland, and 5 years in Scotland. For goods that have a digital element, such as a smart TV or digital content supplied in a physical form, there is a 30-day right to return and get a refund. This right applies if any of the product, including the digital content, for example the software on a smart home appliance, doesn't work properly or develops a fault. The Act defines digital content as data which are produced and supplied in digital form. Just like goods, digital content must be of satisfactory quality, fit for a particular purpose, as described by the seller. If the digital content does not conform to these criteria, there is a right to a repair or replacement of the digital content purchased. If a repair or replacement isn't possible or doesn't fix the problem, the consumer is entitled to ask for a price reduction, which can be up to 100% of the cost of the digital content. The retailer will have to offer compensation if any device or other digital content the consumer owns is damaged as a result of digital content downloaded. This applies where the damage would not have occurred had reasonable care and skill been exercised in the provision of the digital content, even if that content was provided free of charge. This covers any digital content paid for, whether that's with money, a gift card, or credits, and free digital content supplied with goods for which a price was paid. For example, this could be a digital program one needs to download in order to watch a paid-for online streaming service. Also included is free digital content not usually available for free unless the goods, services, or digital content it's supplied with are purchased. For instance, this could be a smart TV, or any other product with digital content pre-installed, paid. The above provisions could cover the situation where your device is damaged by a faulty upgrade, which is automatically downloaded and installed. Watch out, however, for disclaimers and limitation clauses during the download or installation process that may attempt to limit liability for any resulting faults. The retailer is responsible for goods until they are in the customer's physical possession or in the possession of someone appointed by the consumer to accept them. This means that retailers are liable for the service provided by the couriers they employ, while the delivery firm is not liable itself. The retailer is responsible therefore for the goods until they are delivered and in the possession of the customer. This means that there is no need to purchase additional delivery insurance where that is on offer if the seller is shipping from within the UK. There is a default delivery period of 30 days during which the retailer needs to deliver unless a longer period has been agreed. If the retailer fails to deliver within the 30 days or on the date that has been agreed, the consumer can select from the following. If the delivery is later than agreed and it was essential that it was delivered on time, then one has the right to terminate the purchase and get a full refund. If the delivery isn't time essential but another reasonable delivery time can be agreed, the consumer is also within their rights to cancel the order for a full refund. We now move on to consider services. For the supply of a service, the Act, as we saw, provides that the term service covers a wide variety of large and small-scale work carried out in the home or elsewhere. Services can be provided alone or they may be provided with goods, for example the fitting of a new boiler. Examples of services provided without goods include dry cleaning, entertainment, work done by professionals such as solicitors, estate agents and accountants, building work or home improvements. Examples of services provided with goods include repairs to goods where parts are replaced, such as car repairs, fitted kitchens or bathrooms, home improvements involving building and decorating work, and double glazing. In all the above examples, the service contract is governed by the Consumer Rights Act, which means that the consumer can use this as protection should anything go wrong. The rules mean that all contracts for services must ensure the following: the trader must perform the service with reasonable care and skill. Information which is oral or written is binding where the consumer relies on it. Where the price is not agreed beforehand, the service must be provided for a reasonable price. Unless a particular time scale for performing the service is set out or agreed, the service must be carried out in a reasonable time frame. If the service provided doesn't satisfy criteria, the customer will be entitled to the following remedies under the Act. The trader should either redo the element of the service which is inadequate or perform the whole service again at no extra cost, within a reasonable time and without causing significant inconvenience. Or, in circumstances where the repeat performance is impossible or can't be done within a reasonable time or without causing significant inconvenience, the consumer can claim a price reduction. Depending on how severe the failings are, this could be up to 100% of the cost, and the trader should offer a refund within 14 days of agreeing that the consumer is entitled to a refund. Finally, we turn to what the changes in the Consumer Rights Act mean practically for the treatment of unfair contract terms. Rights under the Consumer Rights Act make it easier to challenge hidden fees and charges. The key terms of a contract, including price, may be assessed for fairness unless they are both prominent and transparent. Terms which are not fair are not automatically binding on the consumer, but one may still rely on them if one chooses to do so. Some examples of terms that may be unfair under the Consumer Rights Act include fees and charges hidden in the small print, a term that tries to limit the consumer's legal rights, excessive early termination charges. A term is unfair if, contrary to the requirement of good faith, causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. The fairness test, therefore, includes the following main elements: significant imbalance to the detriment of the consumer and good faith. It must, however, be emphasized that the overall requirement is a unitary one. The question is whether a term is unfair. The elements of the test are recognized as being capable of overlapping with each other in their application to any particular set of relevant facts. A rigid approach to assessing fairness involving an artificial exercise broken into separate parts is not appropriate. Significant imbalance is concerned with the parties' rights and obligations under the contract. The requirement is met if a term is so weighted in favor of a business that it tilts the rights and obligations under the contract significantly in its favor, for instance by granting the trader undue discretion or imposing a disadvantageous burden on the consumer. Examples of the types of terms where an unfair imbalance is likely to arise include those that have the effect of restricting or excluding the customer's normal legal rights to seek damages where the trader is at fault, constraining the consumer from seeking the legal remedies to which their rights give rise, for instance, compelling the consumer to take a dispute to arbitration, and imposing on the consumer additional obligations or risks which are not envisaged by law or unreasonably go beyond anything needed to protect the legitimate interests of the trader, for instance, imposing excessive financial sanctions on the consumer for breaching the contract. It is important to remember that a term or notice that is unfair is not legally binding on consumers. This does not prevent consumers from relying on them if they wish. The Act enables consumers to challenge wording if they consider it unfair and do not wish for it to be relied upon against them. If they make such a challenge and the trader refuses to accept that the wording is unfair, they may wish to consider whether they have a legal case for taking matters further with a view to seeking to resist an apparently unfair demand or to insist that the trader acts in a particular way. Before taking any steps that will or may involve resisting or taking legal proceedings, consumers should always seek legal advice. We have seen some background to the creation of the Act, the details of the statutory provisions, and an explanation on practical consequences for consumers. We will now apply this knowledge to a scenario that involves a common real-life situation and consider how it could be resolved under the new legislation. We will consider the situation of John. John has just bought a new laptop from electrical retailer Frictions. The laptop comes with the Doors operating system pre-installed and was sold with a notice that said "Free upgrade to Doors 10 available." John turned on the new laptop as he returned home and went through the setup process. All was well, and John proceeded to upload his holiday pics from his camera to the laptop, deleting them from the camera's memory in the process. Within the first hour of operation, the laptop displayed a message saying, "Do you wish to upgrade to Doors 10 for free?" John agreed and watched while the laptop downloaded and installed the new version of the operating system. After the installation was complete, the laptop malfunctioned and all personal data stored on the disk was lost, including John's pictures. John took the laptop back to Frictions, but they refused to help as the problem was caused, they said, by software installation from a third party. John contacted FrustraSoft, which makes the Doors operating system, to no avail. John has come to you for advice. The purchase of the laptop comes under the Act, as under Section 5 this was a sales contract between a trader and a consumer. There is no debate here that Frictions is a trader and John is a consumer under Section 2. The problem is not with the hardware aspects of the product, but with digital content, which is covered by Chapter 3 of the Act. The issue here, digital content, the updates to the operating system, give rights to John against the retailer Frictions and additionally, or perhaps instead, to the maker of the software, namely FrustraSoft. One could argue that under Section 33, the operating system, including the upgrade mentioned specifically by the retailer, is for digital content to the consumer, first, supplied free with goods or services or other digital content for which the consumer pays a price, and second, not generally available to consumers unless they have paid a price for it or for goods or services or other digital content. Clearly, Frictions, together with FrustraSoft, wishes customers to select products carrying its operating system, hence the offer of the free upgrade to the latest version. In order to bring a claim against Frictions, John would need to show that the digital content was not of satisfactory quality, Section 34, which would not be very difficult to substantiate in the circumstances. On the basis of the above, note that pre-contractual statements become part of a contract with the consumer by analogy with Section 50. John would have a claim against the retailer for the consequences of the malfunctioning software subsequent to the upgrade under Sections 19 to 22 and any loss suffered, satisfying normal contract law rules on damages claims. Under Section 44, John could claim for damage done to his device and to other digital content. However, it is difficult to quantify loss for the erased pictures. Shaky legal footing were they to dismiss John, saying that they were only responsible for hardware defects with a laptop. The question then becomes, would John have an independent right against FrustraSoft? Were we to see the download of the upgrade independently of the purchase of the laptop, John could rely on Section 49 for liability in negligence for the provision of digital content that causes a defect. This is the old care and skill requirement that was found in the Supply of Goods and Services Act of 1982. One could argue that the provisions of the Consumer Rights Act, Sections 48 and 49, allow this standard to operate independently of a contract, for example as in a tort action, but John could argue for the existence of a contract with FrustraSoft directly too. Consideration in this case would rest in the selection of this particular product, carrying the possibility of the upgrade, as opposed to another one. See, for instance, the case of Shanklin Peer vs. Dettel Products from 1951. In conclusion, John will have a good chance of obtaining a refund or repair or replacement of his laptop and can attempt to claim additional compensation for the loss of his pictures from Frictions, primarily, and potentially FrustraSoft. The introduction of the Consumer Rights Act 2015 highlights John's rights, even though in fact it does not present a radical departure from what his position would have been under prior legislation.